Welcome back to part 2 of our estate planning conversation with Aaron Roepke, a local estate planning attorney here in the Pullman-Moscow area. In this episode, we're shifting gears from the Washington state tax law to the foundations of elements of a good estate plan. What goes into a will versus a trust, how to protect your assets, and practical advice for keeping your plan up to date. Ready to get started? Let's go. So Aaron, I've just gone off broader estate planning topics here. What are the essential components of a comprehensive estate plan?
Yeah, so I touched briefly on this in the last episode, and we want to touch on two things in an estate plan. Who's going to inherit assets when you pass? It's one of our big considerations. That's one of the primary things we're addressing, and we do that through a document called a last will and testament or a revocable living trust. Planning for the possibility of incapacitation. So addressing a situation where I'm still living, but I'm incapacitated and I'm not able to make decisions for myself. We're planning for incapacitation through a document called a power of attorney. And I'll talk about the specifics of powers of attorney in more depth in just a bit. Those would be the basic building blocks. We're planning for transition of assets upon passing. We're planning for the possibility of incapacitation and making sure that we're appointing an agent who can make decisions on your behalf in that.
At what life stages or events in life would you consider people to, one, start looking at an estate plan, and then two, maybe even updating their estate plan?
So life changes and life is unpredictable. And so we're talking about planning for death or incapacitation. I know that's not fun at all to think about. The reality is that any of us could be affected by either of those things at any point in our life. We don't know the timing. So in terms of doing this type of planning, I think you want to do it the earlier the better. A lot of folks hear this term estate planning, and just that term estate brings to mind a vision of a grand estate or sprawling property or whatever that means. But I mean, that's a bit misleading. I think that I would recommend estate planning for anybody that got children. Critical component of an estate plan is planning for the future care of those children, especially if you pass or if you're incapacitated. Making sure that your children are cared for in either circumstance is a critical component to estate. So, you may have a newly married couple that's having their first child, and they may not have a huge estate. They may have purchased a home, and maybe they've got a mortgage on that home. Maybe they have insurance or a life insurance policy that provides death benefit. Beyond that, they've not accumulated significant savings or a significant retirement account. The fact that they have kids is justification enough to have the plan. Taking care of those kids is critical, and planning for the future care of those children is critical. And so I think that for anybody that's got children, I think that's when most people start or should start. And then taking that example, let's just assume that we have a young married couple that does estate planning for the first time, and their plan to start with is focused on their children when they're younger. And so they might have a will where they've named guardian. So in the event that both of the parents pass and one of their children is under the age of 18, they've nominated a guardian who would have care and custody of that child until the child reaches the age of 18. Also have provisions in their plan that say if I pass and my child inherits and my child is under age 25, let's throw 25 out as an example. That would be a circumstance where we have a younger adult or a younger child inheriting, and maybe they're inheriting a significant amount, maybe they're young. And so to provide sort of responsible planning and oversight for that child, we might have trust provisions in the plan that says if my child inherits and if they're under age 25, then we're going to retain their inheritance in a trust. we're going to name a trustee, and we're going to give the trustee the discretion to manage that inheritance for the benefit of that child until they reach age 20. And so that would be a fairly typical plan for somebody that's got younger children. You've got guardian nominations, we've got these trustee provisions. But then we know those children are going to grow, and that might be a good plan that's going to serve their purposes and accomplish their goals until their children are over age 25. That would be a time at which they might revisit their plan. Things have changed. Their children are grown. At this point, they might have grandchildren, and we want to do that kind of planning for their grandchildren. They may have accumulated more assets, and so that would be a circumstance where we would be updating the plan. And then the other critical part about these plans is that you're giving people, not only are you identifying who you want to benefit, so you're leaving assets to a named beneficiary. You're also giving people responsibility, because we're putting together a plan that goes into effect when you're either incapacitated or you've passed, meaning you can't do that work. Somebody else has to. And so with a will, an important consideration, you have to name an executor. If you think about a will as a set of instructions, your executor's job is to execute those instructions, to make sure that those instructions are carried out at the appropriate time. And so that's an important consideration, making sure that we've given that responsibility to the correct person, and also thinking through a possible succession plan just in case the person that you've named is unable to.
Perfect.
Right. What are some common myths, or maybe misconceptions is a better word, about estate planning that you frequently encounter?
Yeah, there's two that come to mind. There's sort of this fear, and you hear people talk about, oh, you need to do a will or the state's going to get your property. It's just this idea that if you don't do a will, then whatever state you're living in or the government or whoever is going to inherit your. And that's true. What you need to understand, and this happens a lot of people don't have an estate plan. And in that case, then we're going to look to the state in which you're domiciled in at the time you pass, and every state has default statute that are going to have a default estate plan for somebody that's passed without a will. And they're based on a presumption that you want your assets to transfer to your nearest living heirs. And so if you're survived by a spouse, we look to your spouse. If you're survived by children, we look to children. If you're not survived by spouse or children, then we might look to parents or to siblings or nieces and nephews and so on and so forth. And that may be what you want. It may not be what you want, but you're not able to make decisions about who should be guardian. If you're not doing a plan, you're not able to make decisions about who should serve as executor if you're not doing the plan. And only in an event where you don't have a living heir. If you're not survived by children or grandchildren or parents or siblings or nieces and nephews or aunts and uncles or cousins, then in that event, we would have a situation where the state might benefit from your asset. It's been so rarely that's a big misconception. And then the second, so Washington and Idaho, they're community property states. And I think because of that, a lot of people assume that just by default, that if you're married and you pass away, that your assets will automatically transfer to your surviving spouse without any type of legal process being involved. And again, that is a common misconception. We talked about the intestate succession statutes when somebody passes away without a will, and we talked about looking to a spouse if you're survived by your spouse. But that would happen through a legal process called probate. And a lot of people don't know that. And they just assume, well, I was married. This house is mine, even though, they're trying to sell it after a spouse has passed and we still have a deceased spouse's name on the deed to the house. So there was the formal process that's required in order to transfer assets from the first spouse to pass to the survivor. And I think a lot of people assume that happens automatically because we're in community property state.
That makes sense.
What are some of the pros and cons using will versus revocable living trust, specifically in Washington state?
Yeah, I like the way you frame the question because that's a good way to think about it. We've got two different ways to do this. If we're using a will or a trust, the task is the same. We're identifying who we want to inherit. We're putting instructions in the document about who's going to inherit and what they're going to inherit. And they're both leading to the same place, but they're taking different roads to get there. So a will, I think the main advantage of a will is its simplicity. If we're looking at doing this type of planning and we're looking for the simplest option, then a last will and testament is the simplest way for us to do that. So that's its biggest pro. It's a document where you're going to sit down, you're going to think about who you want to be your executor, you're going to name an executor, and you're going to identify who you want to inherit assets. That should contain those two things. Now, that makes it easiest. It's simple for the person putting together the plan. So if I'm looking at doing planning, my simplest option is through a last will and testament. But the process of administering that plan after I've passed is a little bit more complicated. And that process that we're looking to do that through is called probate. Probate is just a legal process. Sometimes it's complicated, sometimes it's expensive, sometimes it's hard. A lot of the times it's not. It's not necessarily something to be afraid of. But it is a legal process that is supervised and is run through the state court system. So in order to probate a will, we have to involve a court. And usually your executor is hiring an attorney and there's some legal fees associated with it. It's all governed by state statute. We're going to be looking into the states in which you're domiciled in at the time you pass to determine where we would do probate. The process itself is fairly intuitive. In your will, you'll name an executor. A lot of people assume, well, I've been named as the executor, so I can do this now after somebody's passed. The executor doesn't have authority to administer the estate until a court has given them that authority. And that's the first step in probate, is having a court appoint the executor. Issuing an order giving them legal power and authority to begin administering the estate. Once that happens, there's a process for notifying creditors and paying off any outstanding debts. There's a process for getting taxes paid. There's a process for paying expenses associated with the administration of the estate. Then there's a process for making sure that whoever's listed in the will is going to inherit what they're supposed to inherit. And so that's kind of the probate process. Personal representative or executor appoint, pay off debt, taxes, and expenses. We distribute items to the intended beneficiary. So I think of the will in that regard. Simple for the person creating it, and that's a pro. But there's work to be done by the executor to administer it the back end, and that's a little bit more complicated, and that's a potential con. So it just depends on how you're looking at this. If you want to make it easy for yourself and you're not necessarily concerned about the work of administering the estate after you've passed, the will's probably the way to go. Now, a trust represents the opposite. So if you're concerned about making it as easy as possible for your children or your beneficiaries or whoever you've given responsibility to administer your estate, if you're trying to make the job as easy as possible for the administrator, then the trust is the way to go. But potential con is it's harder for you to set up. And a trust requires the work on the front end. And I don't know how many of you are familiar with trust, but part of setting up a trust is going through a process called funding, where we're funding your trust. And we have to transfer assets from you to the trust. We need the trust to be the legal owner of an asset in order for this to work. And that can be quite a bit of work. So think about kind of a comprehensive retitling process where we're looking at bank accounts and we're looking at real estate and we're looking at vehicles and we're talking about retitling all of those assets to different entity. Potentially quite a bit of work. The other thing with the trust that we got to make sure we're staying on top of is future acquisitions. So if you have a trust and you've funded the trust, but then you're buying assets in the future, we need that those acquisitions are also being titled to the trust. And so you got to keep track of it. You've got to make sure you're filtering your titled assets through the trust. And that has to happen in order to avoid probate. Otherwise, with the trust, if we don't stay on top of those titling issues, if a person passes and we find some of their assets are owned by the trust and some are not, we may still end up having to do a probate. So it's more to track. It represents a higher maintenance estate plan. You have to be more active and intentional about your estate plan when you're working with a revocable living trust than you do with the last will and testament. But the payoff is that it makes administration of your estate a bit simpler after you've passed.
I'm hearing you correctly then, where people would benefit with the revocable living trust over a will is come upon their passing, their heirs, it's a lot quicker, a lot easier for them to inherit the assets. Is that kind of what you're telling me there?
Yeah, it makes it simpler. The administration's simpler. As long as everything's funded correctly, as long as assets are titled correctly. So if the person creating the trust has done their work, if they've done their due diligence and they've maintained their trust appropriately, then it makes it easier for the intended beneficiaries. I think for a lot of people, that's an important consideration in the estate plan. The main benefit of your plan is making sure we're executing the plan. We're carrying out the plan upon somebody's passing. The whole point and goal of this is to provide an efficient way to transfer assets to loved ones, to do it in a tax-efficient manner, and to do it in a way that's not going to cause additional stress in an already stressful situation.
I'm glad you mentioned the stress because as a follow-up question to that, oftentimes we'd want to think that our loved ones are going to all get along after our passing. Does one, the will or the trust over the other, make more sense if there might be some family strife present?
Well, all of this is pretty subjective and it's going to depend on,
of course,
every family dynamic is different. And so there's not just one size fits all advice. One's better than the other for this versus this. And it's going to depend on the individual circumstances and the family dynamics. Either can be challenged. And so if we know that there's possible challenge, if we know that there's a beneficiary that's maybe been left out or is getting a lesser amount than somebody else and they're threatening to challenge what's been done, it's generally pretty hard to challenge either. I think there's more planning opportunities, especially with the trust than there is with the will, especially considering what happens upon the death of a first spouse when we're considering a married couple. And so let's say we have a married couple who each have wills, and they have mirror provisions within those wills, and they start by, when I pass, if I'm survived by my spouse, I leave my estate to my spouse. And then the first spouse passes, surviving spouse inherits. That is now complete. So the first spouse who passed, their will has been administered. They've transferred assets to the survivor. The surviving spouse now owns those assets, and they are free to do what they want with those assets as they please. And now we have this tension in the family, and one kid starts approaching mom saying, change your will to benefit me or exclude sister or whatever the case may be. We can see some conflict there. But one way to potentially plan to avoid that is a trust, and having a provision in the trust that says upon the death of the first spouse, the trust becomes irrevocable. So the trusts it represent a joint plan. It's holding joint assets of a couple. And while both members of the couple are alive, they can change it or amend it and do what they want with it. But upon the death of the first, it becomes irrevocable, and then the survivor can't change it so that it benefits anyone else. And so there's some protection and safeguard in doing that. And that's a potential planning opportunity and some control that a lot of folks might like. And that could be in a family situation. We use those a lot in a blended family scenario. We may have a husband and wife, but they've got children from prior relationships, and we want to make sure that we're benefiting the children from those respective relationships, regardless of who passes prior to the other. So that's a very typical arrangement in that scenario. They also provide protection with the trust and that irrevocability provision upon the death of the first spouse. Think about a situation where a surviving spouse might have a later in life relationship. Maybe they meet a new boyfriend or girlfriend, or maybe there's a later in life marriage and an inclination to change the trust and leave assets to that new boyfriend or girlfriend or the new spouse. There's protection in that scenario.
Mm-hmm.
And then finally, I mean, we're seeing this happen a lot now, and it's frankly pretty alarming, but just seeing how aggressive people are targeting elderly people in terms of the amount of fraud and scamming that's going on.
Mm-hmm.
And so there's protection there too. So maybe we have somebody with a trust that became irrevocable upon death of the spouse, and they're now older. Maybe they're vulnerable and they've got some cognitive decline going on. And there's a caregiver that's come into the home, and they're whispering in the ear of that spouse to change their plan, benefit me. There's protection against that with this provision in this trust.
Smart.
So I think that the trust gives us some additional planning opportunities to protect in some of those situations. And I would generally say protect against outside influence, somebody trying to influence the plan other than the people who created it, which would have been husband and wife. And we can do that through this provision that makes the trust irrevocable upon the death.
Thank you.
How do currencies and digital properties fall into this into this estate planning scenario here?
Yeah, so this is a recent subject to this conversation about estate planning. We're planning for asset transition, and in today's world, that could mean you can have a diverse portfolio of assets, anything from real estate to digital and electronic assets. And even within that digital and electronic asset category, that could range from cryptocurrencies to it may be an artist's digital portfolio that's being stored through some electronic means, but it's got value. It may be information stored on a device that's password protected. Think about a locked iPhone, a locked computer. The law is adapting to answer a lot of these questions, but these need to be addressed in the plan. And we have language that we provide in all of our planning documents. There's uniform law that allows a fiduciary to access digital and electronic assets. So if you're thinking about an executor trying to administer an estate, and let's say that there's important information regarding an asset that's on a locked phone, and the executor doesn't have a password, this uniform law provides a somewhat efficient way for us to get access to those assets. And it may be an email account that we don't know the password to. It may be a locked device. It might be a social media platform or something like that. But that's one thing that we want to plan for. And then the other thing is just thinking about who's administering the assets, especially with cryptocurrency. If we've got somebody kind of managing the account, we want to make sure that we're having conversations with the account manager just to see if there's something we need to know and how to transition that account or the value of the account to whoever it needs to be transitioned to. So we want to make sure we're talking with the account managers and not just assuming that we put a provision in the will and this is going to work. It may or may not. So we want to make sure it's all about communicating. The plan involves a lot of communicating. We want to make sure we're talking with those account managers to ensure a smooth transition of that account. And then also sharing important information about those accounts with the people that we're relying on to carry out the terms of the plan. So your executor, for example, or a trustee under a revocable trust, just having contextual information. So just maybe a list. I have account here. I've got crypto accounts here. I have investments with this brokerage. I've got CDs at this bank. Here's the name of my financial advisor. Here's the name of my CPA. Here's the name of my attorney. I've got a safety deposit box at this bank. All of that kind of information. I've got a password protected account here. The password is this. Just having that. Obviously, it's sensitive information. Obviously, it needs to be protected, but having that available to the trusted person that you're relying on to administer your estate is, especially digital assets. I mean, that's really important.
Yeah. Be thrown away. So might have quite a few digital assets on those.
No dumpster diving for hard drives.
When you try to avoid that if possible.
Yeah. You touched on something about communication, and communication is so important, not just in estate planning, but in financial planning in our lives as well. How do powers of attorney, healthcare directives, living wills, et cetera, fit into a complete estate plan?
Yeah, so powers of attorney and healthcare directives are documents where we're planning for the possibility of incapacitation. So we're not planning for death. We're planning for a circumstance where you're living, but you're incapacitated. And in that circumstance, we want someone that you trust to be able to act on your behalf. And that's the primary task with the power of attorney. It's a document where you're naming an agent, and this should be somebody that you trust. It's an important decision. It's an important job. It should be somebody that can act in your best interest and somebody that's willing and able to do so. So a lot of consideration should go into who you name as agent. You should also probably name some alternates just in case whoever you've named as your agent can't do this for any reason. And you want to make sure in that circumstance, obviously, if you're incapacitated, you're in a vulnerable situation, and you want to make sure that somebody that you trust can make decisions for you, can act on your behalf. We typically do financial powers of attorney where you're naming an agent and you're giving them general and broad power to make financial decisions for you. So there should be somebody who can continue to pay bills and expenses on your behalf, somebody that continue to manage, invest assets on your behalf. somebody that can pay any outstanding debt or taxes, all of those types of expenses and obligations. So we want to make sure that there's somebody that can act on your behalf in that financial capacity if you're unable to do so for yourself. Same thing with healthcare. If you're not able to make healthcare decisions for yourself because you're incapacitated, then that, again, a document with named an agent and you've given them general power and permission to make healthcare decisions for you in that circumstance. If you think about this situation, if we take this out of a hypothetical scenario and we're thinking about it in real time, and you've named an agent under a power of attorney, and then your power of attorney is presenting this document to a financial advisor. That may come as a surprise to the advisor, or maybe we have a healthcare power of attorney being presented to a physician or healthcare provider. But if there's been communication about it beforehand, if these documents have been shared with the people that you're relying on and that you're trusting to provide services on your behalf, whether it's a financial advisor or a healthcare provider or an accountant, that way there's at least settled expectations. At least people know that if something goes wrong, if somebody's incapacitated, then we know what to expect here. We know who has authority. We know who to talk to. And that goes a long way in making sure that these situations are the least stressful as possible. They're already stressful just because we're dealing with stressful issues. The communication goes a long way. I would encourage everybody to have a financial power of attorney and a healthcare power of attorney, and make sure you're talking candidly with your professional advisors, whether a financial advisor or an accountant, so that they know who you've given that responsibility to.
Great. Yeah, I know that's so important in our world for sure. So talk a little bit, if you can, about the role of beneficiary designations, so account-specific beneficiary designations, and how possibly they can conflict with or undermine a will or trust.
Yeah, so whenever I'm sitting down with somebody, assume I'm meeting with somebody for the first time to discuss an estate plan, my typical process is to send out a questionnaire in advance, and there's an asset schedule in that questionnaire, and I ask people to kind of list out their assets, including real estate, retirement, financial accounts, bank accounts, etc. And part of that process is me kind of going through that with my client and making sure they understand the categories in which their assets are being placed. So a lot of folks assume if I've got a will, all of my assets are going to transfer pursuant to the provisions of the will. And this is a big one, just making that assumption. But if I'm going through somebody's schedule of assets, I'm instinctively putting those assets into one of two different categories. The first category I would call probate assets, and these are assets that are going to transfer through probate unless we use a revocable living trust. And the next category I would call non-probate assets. These are assets that have there's some type of way for them to transfer outside of probate. Typically, that through a beneficiary designation. So common examples of a non-probate asset, first and foremost, would be a life insurance policy. When you get the policy, you designate beneficiaries. You name a beneficiary, and that beneficiary will get the benefit upon somebody's passing. And when we're looking to payment of that benefit, we're looking exclusively to the beneficiary designation. We're not looking to your will to determine who gets paid the death benefit under the insurance policy. The same would be true of retirement accounts. So a lot of folks may have an IRA or a Roth IRA, or maybe they have some sort of employer contribution plan, a 401k plan. When they set that account up, they designate it beneficiary. And the money in that account will transfer to the named beneficiary. upon their passing. And we're looking exclusively to the beneficiary designation to determine who gets that account when somebody passes. Your will has nothing to do with the transfer of those non-probate assets. We're looking only to the beneficiary designation. So if there's any sort of disagreement, let's say that you have a will, and in your will you say, I leave my IRA to A, B, and C. But then the beneficiary on that IRA is X, Y, and Z. The account is going to transfer to the named beneficiaries. We're not looking to your will to determine what happens with the account. So in that example, the account's transferring to X, Y, and Z as the named beneficiaries, not to A, B, and C, even though they're named in the will. So we got to make sure those are two different categories of assets. I tell my clients to think of these as buckets. We've got these assets in bucket A, these assets in bucket B, and we want to make sure that there's a coordinated plan for both. And so we want to make sure that we're coordinating your will and your beneficiary designation so that we have a comprehensive plan that's working all together.
And that's true even if, say, I updated my IRA beneficiaries in 2015 and then had my will done in 2025. They're still going to go back to the IRA beneficiaries that were designated in 2015, correct?
They're going to look at the beneficiary designation. So whoever's managing that account, whoever the account manager is for that IRA, when it comes time to transfer the account upon somebody's passing, they don't even care what the will says. Unless you've named your estate as the beneficiary. Sometimes may be advisable, sometimes it may not. But if you've got an individual person named, we're looking only to that person. And that's going to happen outside of probate. It's not going to even, your will, it's not even part of the administration of your probate estate. Nothing to do with your.
Perfect.
And that can become specifically impactful if in case, like say divorce, where if you and your previous partner have separated and your ex is your primary beneficiary and
forgot to update that
10 years later.
Yeah. So it's important to review those designations and make sure, especially, I mean, if you're updating your will or you're going through this estate planning process, I always encourage my clients, and even if they tell me, oh, I just updated these, I know what they are. I'll tell them, just double check. Just make sure, let's make sure that while we're doing this, you're double checking your beneficiary designations and potentially considering updating those designations if necessary.
Exactly.
Perfect.
Great.
So what advice would you have for someone who is just starting out on the estate planning process?
Well, I think you should do it for sure. So my first advice is it's important. I also recognize it's difficult. This is difficult planning. It's intimidating. We're talking about things that are hard to talk about. We're talking about planning for incapacitation. We're talking about planning for your passing. Those are hard things to think. The law around this area is complicated. It can be intimidating working with the professionals around this area. I would say that you need to do it. Most people don't because it is hard. It does cost some money, but I would think of it this way. I mean, this is a plan to make sure that your life's work, what you've accumulated throughout your lifetime of work, is transitioned responsibly and effectively to the people you care about. And so it's something you want to invest in. It's something that's okay to spend time thinking about. It's something that's okay to talk about and have serious conversations about. Important. And it's often the times that if you do it well beforehand and you put the time and energy and investment into doing it well beforehand, less expensive than if you didn't do it and something goes wrong. And so I think there's a lot of barriers to entry on people taking that first step. It can be intimidating just because of the subject matter, because it's outside of a lot of people's wheelhouse. It's something that we're used to talking about. A lot of these subjects are kind of taboo. But taking that first step, understanding that it's a step-by-step process, and just understanding the value in it, seeing the big picture, understanding the big picture value in what you're doing, you're planning for the transition of your life's work. And saying it that way, it's obvious the significance. And so it's important to.
Awesome. And then you've kind of alluded to this a little bit. And when it comes to our world, I like to say it's financial planning, not just a financial plan. You were kind of saying, yep, we want to update this as time goes on. It's more estate planning than just an estate plan. How would you recommend people best keep their estate plans current as they go along that path?
Well, there are some obvious things that may happen where you would want to update. So let's assume that you've got an estate plan and you've got powers of attorney and you've named an agent, and something happens to your agent and you know that they can no longer serve in that capacity. So that would be an obvious reason to update your plan. You've given responsibility to somebody and that person can no longer. There could be changes in relationships. This could be through a divorce. Could be divorce between spouses. Maybe you've named guardians for minor children and you named a husband and wife to be guardians of a minor child, and that couple divorces. That would be a reason to date your plan. I would say, as a general rule of thumb, you want to review your plan probably every 2 to 3 years. It doesn't have to be an in-depth review, and it doesn't necessarily have to be with an attorney or a professional, but just personally and privately review that plan to hit the main points and confirm that it still accomplishes what you wanted to accomplish, that it's still consistent with your wishes and accomplishes your goals as you want them to be accomplished. That would be my general advice. Every 2 to 3 years, review it and make sure that it still accomplishes what you hope. I know on my end, when I'm putting together an estate plan, I put a lot of thought and energy into making it flexible so that we don't have to. I want your plan to work well in lots of different circumstances because I know I can't assume I know what the circumstances will look like when you pass. And so I want it to be flexible. We can't predict everything. And so that, at least reviewing every few years, keeps it fresh and it may bring something up where you're like, you know what, I've just remembered I wanted to change this, or I know that this person has moved, or they're sick themselves, or there's some circumstance in which they can't do what you were hoping they could do. Those are all reasons to date your.
Awesome. Thank you.
And lastly, it's kind of a two-part question. What are some first steps for someone who might be overwhelmed or intimidated to start their estate planning process? What are some things that they can do either mentally or physically to start the process? And then conversely, how can they best be prepared for the professional that they might engage?
Yeah, so I think just start by keeping it simple and asking simple questions. So the questions that need to be answered are the same across the boards. First and foremost, if we're talking about a will or a trust, you've got to identify who you want to inherit. And that might be where you start. Just say, these are the people that I want to inherit. And you just list their names. This is who I want to inherit. I want my spouse to inherit if I pass before my spouse, and if not, then I want my children to inherit. Identify that, just the big picture goal and the overall structure of the plan. And then we can build off of. So that foundation is probably the most fundamental question to ask. It's a pretty straightforward question, and I start with that, just identifying who's going to inherit. And then identify who you're going to give responsibility to. So understand that part of this plan, you're going to rely on people to carry this plan out. And you've got to give people some important work to do. And you need to identify who you want to give that responsibility to. So you just got to identify the actors, the players, the people that are going to benefit, the people that are going to have responsibility. So I think you start with that. And at its core, that's where we want to start. If you came to me with only that, I can build off that. We can go from there, and we're going to be well on our way to putting together a good plan for you. For me, whenever I'm meeting with somebody for the first time to discuss this, I send a questionnaire out, and the questionnaire can be intimidating, but I'm just asking people to do the best with the questionnaire. But I need some information in order to put the plan together. The questionnaire has detailed information about your family, whether you're married, who your spouse, the names of children, the names of siblings, nephews. So just me kind of getting oriented to your specific family situation. And then there's an asset schedule. So I want to know if we're putting together an estate plan and we're planning for the transition of your assets, I need to know what your assets are. We have an asset schedule where we can list that out. And even if you don't know all of that, it's not critical. And we can talk through that in our first meeting. I can kind of walk you through some of this. But that's just meant to get me oriented to your specific situation. If you work with professionals, this should be a team approach. And my job as the estate planning attorney is to walk you through the legal planning and the logistics legally of the estate plan. But I also need to partner with and communicate with your financial advisors and your accountants. This type of planning, this type of advising, it should be a team approach. You should be doing it with your group of trusted professionals and your group of professional advisors. So even if you're intimidated by something, but you've got a financial advisor you trust, you may give your advisor permission to speak with me about the details of the plan, and we can coordinate together. And so that may be a way to kind of ease that and make it a little less intimidating, is just letting your professionals coordinate and communicate between each other. But at its core, if you could give, if you're meeting with an estate planning attorney, if you can identify who's going to inherit, who's going to have responsibility, that's going to get you well on your way. And that's the first step, and that's where I would start.
Great. Well, we really appreciate you, Aaron. If somebody wanted to engage you, how would they find you?
Yeah, so I work for the law firm Westberg, Roepke Moore. We are in Moscow, Idaho. We've got our office in Moscow. We are in the process of opening an office in Pullman. We will be expanding into Pullman in the near future. I would say about a month or so. We'll be opening a Pullman office. Our Moscow office is located at 530 South Asbury Street in Moscow, Idaho. Office phone number 208-883-1520. That would be the best way to contact me to move forward. If you're interested in any help with any of this, this is what I do. I'm primarily engaged in estate planning, estate administration, so I'm happy to meet with anybody to discuss specifics.
Awesome. Thank you. Well, that concludes our estate planning series with Aaron Roepke. Thank you very much. Whether you're just getting started or revisiting your plan, we hope you're walking away with some clarity and some confidence in your journey. If you'd like help aligning your estate plan with your financial goals, you can connect with us at mywhitehill.com. And don't forget to share this episode with someone who needs to hear it. Thank you so much. Have a great day.